My name is Patrick Foster. I'm a Buffalo Public School teacher. I teach at International Prep at Grover, Cleveland. And I'm here to teach you a lesson today on the Supreme Court, the growing power of the Supreme Court, and how throughout American history this power has grown, what that looks like today, and also to compare two of the most more well-known and important courts in our history. And we have the John Marshall Court of the 1800s and the Earl Warren Court of the 1950s. And we'll be asking students to work with that material to form a Venn diagram at the end of the lesson. So the lesson is on the Supreme Court and the United States history. Our essential question today is, what impact has the Supreme Court had on United States history? Here we have a picture of the current court. The current court today is called the Roberts Court. John Roberts is our Chief Justice. He has been since 2005. Here's a picture of the Supreme Court building in Washington, D.C. Our lesson objectives. Learners will be able to explain how the Supreme Court's power has increased over time. Learners will be able to compare and contrast the historical impact of the Marshall Court and the Warren Court by completion of a Venn diagram. So that will be the product that we'll be asking you to complete at the end of the lesson. First, I want to begin by talking about today's Supreme Court. George W. Bush in 2005 appointed John Roberts, who's a native of Buffalo, to be the Chief Justice of our Supreme Court, and he is the current Supreme Court Chief Justice. The Roberts Court, since 2005, is known for its conservative opinions that it's rendered, but also a highly important decision that was passed down in 2015, which we'll speak about in a moment. Often Roberts has been seen as the compromise vote, sort of the mediator vote between the conservative and the liberal forces on the Supreme Court. President Trump recently appointed two justices, Justice Brett Kavanaugh and Neil Gorsuch, to the court to replace a justice who had passed away, as well as one who had retired, and that's given the court a conservative flavor. However, the Obergefell versus Hodges case in June of 2015 for the Roberts Court was a socially liberal decision, which has had a tremendous impact on United States history today, and this is a good example of how powerful the court is at this point. The court ruled that same-sex marriage is legally protected under the Constitution's 14th Amendment, and specifically under the Equal Protection Clause and the Due Process Clauses of the Constitution. The court ruled that individual states do not have the right to deny same-sex couples a marriage license. The court ruled that individual states could not deny or abridge the legality of a marriage license issued by another state to a same-sex couple. So the Roberts Court currently, although conservative typically by nature in its decisions, has had a socially liberal decision such as the Obergefell decision in 2015. I want to look a little bit at the basis of the Supreme Court's power. So first, we have in the Constitution, Article 3 of the Constitution delineates that there shall be a Supreme Court, but it's fairly general in the way it states that. In terms of how many judges are on the Supreme Court and how the lower courts are actually established and structured is to be set up by the legislative branch. And so that says that in the introduction. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme Court and inferior courts, shall hold their offices during good behavior and shall at times receive for their services a compensation which shall not be diminished during their continuance in office. The power of the court was greatly enhanced, however, not yet realized, by Federalist Paper number 78, written by Alexander Hamilton. Federalist Papers were a group of op-ed papers that had been published in newspapers around the time that the Constitution was being debated to be ratified. And Hamilton was trying to explain and give commentary on how the Constitution works. Mostly what he wanted to do was to assure Americans that the Constitution with the judicial branch would not violate the powers of the other two branches or would not be too powerful. In a sense, he tried to argue that the judicial branch was the weakest of the other two branches because it lacked the powers of the sword and the power of the purse. And basically that the Supreme Court's power would be to act as a guardian of democracy. They would be an intermediary between the Constitution and the people, and between the legislative branch and the people. Hamilton, in so doing this, established that the ultimate power of the Supreme Court was through what was called judicial review. And this was the power to declare, to invalidate basically state or federal laws if they violated the Constitution. They could declare that laws were unconstitutional. As quoted in Federalist Paper 78, Hamilton says, any legislative act that contradicts the Constitution is no law, is in fact unconstitutional. In order to make the Supreme Court powerful, however, Hamilton had to do something. He had to make the positions on the Supreme Court permanent positions, and also guarantee the independence of the judiciary, or the independence of the judicial branch from the authorities of the legislative branch and the executive branch. And remember, the executive branch and the legislative branch had the power of using force or using will. That would be the power of the sword, as well as the power of the purse, which is the power to raise taxes or to do revenue bills, which is what the legislative branch can do. So Hamilton warned, he said, really, those powers are the most likely to violate the Constitution. The judicial branch instead will not violate the Constitution. They will protect the Constitution and protect the people. One of the ironies, and this is what I have right here, that says the irony of Hamilton's Federalist Paper 78. Hamilton at the time was trying to show and assure people that the judicial branch would not be a threat to liberty, but in reality, the irony is that the Supreme Court's power has exponentially increased over time. So even Hamilton most likely didn't foresee that this would actually happen. He was assuring people that this branch was in many ways considered the weakest branch, and it was really no threat, but yet he was bolstering up its power to do this important job, which was to protect the Constitution, but yet is unlikely that he foresaw that it would become as powerful as it has. And today that's what it is. It's the body that can really set national policy, hearing cases that deal with interpreting the Constitution, with cases dealing with federal law. So that's one of the ironies that we see. The power of the Supreme Court today. The way in which the Supreme Court is powerful today is as an interpreter of the Constitution, it is practicing judicial review. And what this is the power to declare a law unconstitutional or to invalidate laws that violate the Constitution. Really, they are the interpreters of the meaning of federal law and also the Constitution. But what makes them quite powerful today is the practice of judicial activism. So I want to look at that for a moment. Judicial activism versus judicial restraint. Activism is when the court uses its power to advance a preferred social agenda. So the two courts that we're going to look closely at today are the Marshall Court and the Warren Court. Both of them, in their own ways, used judicial activism. Judicial restraint, on the other hand, is when the court tends to leave intact or in place lower court decisions, state court decisions, federal court decisions that are lower, and to leave them in place and to take what we refer to as a narrow interpretation to the law. The two courts that we're going to look at today are going to be activist courts. That's going to be one similarity that we're going to pay attention to. The Roberts Court, interesting enough, which is the current court we live under today, has practiced both, restraint and activism. In the case of the same-sex marriage case, they were practicing judicial activism. In other cases, they have done judicial restraint. And so the first court that we're going to take a look at, and I think we're going to do this in our next segment, is the Marshall Court, beginning in the early 1800s. So when I return, we'll start up and we'll talk a little bit about John Marshall. Welcome back, Buffalo. So we're going to continue our lesson on the Supreme Court and the growing power of the court. And to look at that, we'll look at the Chief Justice John Marshall epoch of the Supreme Court, which begins in the 1800s, 1801 specifically. He is appointed as Chief Justice, and Marshall was of the Federalist Party, which, if we look at our American history, we know the Federalist Party was a lot about increasing the strength of the national government, particularly over the states, which had exerted their independence and their rights to stand up to the federal government. So one of Marshall's chief roles as Chief Justice of the Supreme Court is to use his activist stance as a judge to sort of propel forward the growth of the national government and also the federal government's power over the states, to sort of establish that. And this is in the system of federalism, which was one of the principles of the Constitution. The idea that the federal government was supreme to the states was something that the states had kept standing up to the government, and it had not been established in practice. So Marshall, in his first major decision, the Marbury versus Madison decision, you're going to see in practice judicial review, which was what Hamilton had written about in Federalist Paper 78, but yet it had not been realized until the actual court decision of Marbury versus Madison. So I've listed here 4 of the major cases that Justice Marshall, his court, was responsible for. And John Marshall is going to serve throughout the 1800s through the first half of the century of the 1800s. Sometimes he's called the Super Bowl quarterback of the Supreme Court. He's seen as sort of this major figure who really props up the power of the Supreme Court. And again, prior to this, we really, we had in the Constitution, Article 3, we had Federalist Paper 78. Even the first Chief Justice, John Jay, had not really used the court's power in a way that would have established it as a powerful entity of the government. So by now, we have the judicial branch under Marshall. It's going to really establish itself as something to be reckoned with, a force to be reckoned with. And the first concept that I'd like you to look at is this concept called judicial nationalism. So one of the things that the Marshall Court and also the Warren Court and even the Roberts Court today, they are in many ways an expression or sort of a something that is happening with respect to the context of the time. So the Marshall Court is throughout the early 1800s. The country at this time is a young republic, and it's starting to expand. We have this concept of nationalism throughout the country. Nationalism economically, nationalism in foreign policy. We have the country kind of growing in its own strength. And so the Marshall Court's going to reflect that growing strength of the country throughout the 1800s. And that would be under just the plain old term nationalism, the growing power and strength of the country. But we can use this term judicial nationalism to say, what exactly did the Supreme Court do to show an expanding nationalism throughout the country in the 1800s? So starts with the Marbury-Madison decision. In the Marbury-Madison decision, the Supreme Court demonstrates its power of judicial review by striking down an existing law. And this was called the Judiciary Act of 1789. And what that act had done is it had given the Supreme Court the power, it was called the writ of mandamus, a power to actually order somebody in the government to do something. And what Marshall said was that this was an unconstitutional power. It had been granted to the Supreme Court outside of the bounds of the Constitution. In other words, the Judiciary Act was a law passed by Congress. Congress only had the power to pass laws that deal with the appellate jurisdiction of the court, which is setting up the structure in the lower court system, the federal court system itself. But the original jurisdiction of the court involved cases that the Supreme Court would handle, disputes between states and between federal officials. And that was solely in the power of the Supreme Court. There would be no acts that could grant a writ of mandamus into that realm or into that part of the court, which was the original jurisdiction. kind of a complicated case, as I'm sure you're hearing from me at this point. But what happened with that, by striking down the Judiciary Act of 1789, a lot of people will say, well, hey, he took power away from the court. But in the short term, he took power from the court, but in the long term, he showed that the court had an exponential, unlimited amount of power to do this with all laws. All state and federal laws were now subject to judicial review. So by striking down the Judiciary Act of 1789, even though it temporarily weakened the position of the Supreme Court by taking away its writ of mandamus, it actually, in fact, gave the Supreme Court a precedent, an example for the future that it had effectively invalidated a law that it was declaring unconstitutional. So that now the court could do this, you know, in all cases where there was a federal question or a case of interpreting the Constitution and federal laws or state laws to make sure that they follow the Constitution. So that's the first case. The other cases, we have McCulloch versus Maryland. We have a case where the National Bank, which Alexander Hamilton had been, as part of his financial plan, had created. And we had the state of Maryland posing a challenge to the National Bank. Inside the state of Maryland, the state of Maryland attempted to destroy the National Bank by taxing it with state taxes. And what Marshall rules in this case is that the supremacy clause of the Constitution within Article 6 says that the federal government, the laws of the federal government are supreme to state laws when there's a conflict of the two laws. And so essentially what Marshall did is he ruled that the federal government's power is stronger or trumps the actual power of the state governments. And that was in the McCulloch, Maryland case. Gibbons versus Ogden, we have a case where Marshall puts into practice the Commerce Clause of the Constitution, saying that Congress has the right to regulate trade across state lines. It happened to do with a case with a gentleman who was looking where would his license to operate his steamboat come from, which state, since the river he was operating on went through more than one state. And the answer to that was that Congress, the United States Congress, would hold the power to regulate trade across state lines. One of the effects of that case was to expand business operations in America, that businesses would now sort of be looking to the federal government more than to states for regulation. And it led to an expanding of manufacturing and industry in the country. Again, going along with our theme of nationalism, expanding the power of the country. So in all three of these cases, you see that what Marshall has done is he has illustrated the power of the federal government over the states. He has increased the federal government's power, first by making the Supreme Court stronger in the Marbury case. Secondly, by showing that the National Bank, which is a federal entity, cannot be pushed around or be taxed by a state government. And then in the case of Gibbons versus Ogden, where Congress, which is in the federal government, has the power to regulate trade. Not the individual states, but that the federal government has the power. And that'll conclude our second segment of the lesson today. And we will return and we'll talk about Earl Warren. And welcome back. And now we're going to switch into a little bit of a analysis and study of Earl Warren and the Warren Court. And one of the things we say with the Supreme Court is the significance of the court is shown if you have a Chief Justice who serves a particularly long term, and during his leadership or her leadership, we have a number of landmark cases that have changed sort of the trajectory of the country in terms of social, economic, or political movement of the country and progress, then the court holds the name of that Chief Justice, and that's kind of how we look at it historically in our curriculum. So the Warren Court in the 1950s up through 1969 is going to be known for civil rights and rights of individuals and rights of those accused of crimes, the rights of the criminally accused. And again, the court practices judicial activism. One of the ways in which the court shows its power over the American polity is to look at ways in which the court's decisions have maybe advanced a particular progressive cause or a particular social agenda, in this case, civil rights, to start with. So we have America in the southern part of America, we have actual legal segregation going on from the late from the 1870s up through the 1950s. And the case, first major case with the Warren Court is the Brown versus Board of Education decision, 1954. Actually, it was a case that was compiled with perhaps a dozen other cases to advance a challenge to segregation, a challenge to the legality of segregation. And the case of Linda Brown is a young African-American kindergartner who her and her parents would like to see her go to her neighborhood school. There's stories about her kind of looking across the street and seeing the school and then having to be told that this is not the school for her. This was the whites only school, and that the African-American children were to be bused a fairly large distance to a different school, and this is Topeka, Kansas. And this is the challenge to the segregation laws. It's not the first time that this has happened. We have the Homer Plessy case, 1896, Plessy versus Ferguson. In that case, the Supreme Court had taken a narrow interpretation and had ruled that there was no violation of 14th Amendment equality under the law, because if the state of Louisiana could prove that the facilities were equal in the Plessy case, then they upheld the legality to the Louisiana law, which is how the Plessy versus Ferguson's ruling was. And that was the sort of the so-called separate but equal ruling, that as long as facilities like streetcars and public places were equal, that there would be no violation to the 14th Amendment. And that would be more of a judicial restraint decision. And so by the time of the 1950s, however, the social climate has changed. We have the civil rights movement. We have Rosa Parks. We have Dr. Martin Luther King. We have the civil rights movement really getting some momentum and gaining steam. And so in the context of that, we have the Warren Court, which is going to make this landmark decision in the Brown case. And what the decision is that segregation itself is inherently unequal. All right? Inherently, it violates the 14th Amendment, the equal protection, the due process clauses of the Constitution. So they come up with the new term for this is separate but equal is inherently unequal, ruling that segregation in its very self had created a sense of psychologically damaging school children, creating a sense of inferiority and creating inequality and discrimination, that the policy of segregation and the legality of the segregation itself, legalized segregation, was in fact a violation of the 14th Amendment. So now it's declared that separate but equal is inherently unequal. And the court orders that at once desegregation of public schools should happen immediately. And of course that's going to take years to take place, but 1957 we have the Little Rock Nine and the challenge in Little Rock, Arkansas, to this court decision. But we clearly have an activist decision that's going to change the face of America. And that's true for the other Warren Court decisions as well. Loving versus Virginia in 1967 is going to basically say that interracial marriage is now legal. Right? States do not have the right to prevent African American and white from being married. Gideon versus Wainwright is going to say under the due process that in the 14th Amendment that the criminally accused have a right to an attorney even if they cannot afford one, so it's sort of the public defendant case. And then the Miranda versus Arizona, which many of my students always hear that on the crime shows that they may be watching Criminal Minds or other things. You'll hear you have the right to remain silent. The Miranda versus Arizona case those rights come from the Miranda versus Arizona, which is that those who are accused of crimes have the right to be advised of their rights out loud and to be told what their rights are. So these rights, the individual rights for those who are accused of crimes and also civil rights for African Americans were the hallmarks of the Warren Court. And it shows the incredible influence of the Warren Court on American society. So now I was asking students, I've kind of put up a Venn diagram here. In class we would have a Venn diagram that we'd be working on either through our readings or through what the lecture has shown. And I just want to kind of review this with you to conclude. And we would be asking students to have this completed to sort of write out their Venn diagram. And so when we look at the Marshall Court, first of all, we look at how is the Marshall Court different from the Warren Court? Well, first of all, it's much earlier in American history. It's in the 1800s, earlier 1800s up through the 1830s, 1840s. It's going to focus heavily on nationalism, the power of the federal government sort of propping itself up, federal power over states, showing that through the system of federalism that really the supreme power is the federal government, that the states have powers and rights, but the states' powers and rights are less than the federal government's. And this jives with our concept of judicial nationalism, the growing power of the government and the country at the time of the 1800s. We skip down to taking a look at the Warren Court. The time period is much different. We have the 1950s. We have the advancement of civil rights, the social agenda of civil rights. We have the rights of criminally accused in the various cases that I mentioned. When we look at how the two courts are similar, judicial activism is what really stands out. In both cases, the courts took assertive action towards a preferred social agenda. So that's one way in which we can clearly say that these two courts are similar. The Marshall Court, on the one hand, pushing for federal power over states. That was the way the country was moving at the time. Nationalism, growth, strength, the country getting stronger, foreign policy, just the ways in which the country was getting stronger. And then we look at, in the activism of the Warren Court, we look at advancing civil rights and rights of individuals. And of course, in both cases, the role of the U.S. Supreme Court grows, and its influence grows to what we have today. And Hamilton probably would never have seen it as the powerful, it clearly would have seen it as an equal power to balance the other two branches, but unlikely to see that its power is really, really so influential as it is today in setting national policy. Thank you very much.